Okay, good morning, everyone. We were scheduled to start at 9, but that was to allow the parents in this new case to talk with their attorneys, and they've been able to accomplish that. So I'll look forward to their remarks and decisions on how they want to proceed today, in addition to our basics as we go through the preliminary hearing. And then we did have a bench conference also, and I'll let the attorney speak to that as well after appearances.
Lee Heiss, lawyer, guardian ad litem.
Ms. Sasha Thomas, counsel for the department.
Amanda Jones from the department.
Charles Noe on behalf of responding mother.
Okay, double.
Michael McFarland, representing Mr. Patterson. Please introduce yourself. Jeffrey Patterson.
Ms. Spencer.
Alexis Spencer, appearing on behalf of respondent father Austin Doobie.
Thank you. For the record, we've looked for Mr. Doobie here in the courthouse. We've watched for him on Zoom. We've not seen him yet this morning, but we appreciate you staying on, Ms. Spencer, at this preliminary stage of things. All right. Well, let's go through any comments about the cyber.
Thank you, Andrew. There were, as far as it relates to proper service to parents, we were wondering if Mr. Doobie was able to be served. He has not, and we don't have a proof of service filed yet, but for the record, he has not been served. Today, we would ask the court to consider a motion for alternate service, I apologize. We will submit that to the court, and we can take testimony from Ms. Jones if the court has time for that. Otherwise, I think that we were discussing procedurally what the respondent parents would like to do in this case, and if an adjournment would be proper, which I believe we're all in agreement with.
I would agree. I think the adjournment is proper. In addition to that, we did some dates for jury trial, which were agreeable to all the parties. In addition to that, my client, 2 issues. My client is obviously requesting a jury demand. I'll be following that as well. In addition to that, my client has indicated to me that she is agreeable to voluntary service at this point. So she had no problem or objection to that. She certainly wants to do what is necessary and as the court sees fit. So she ultimately is agreeable to that. That being said, in terms of prelim, we are still set for the prelim 2 weeks from today at 1:30, and that day is agreeable to myself and my client.
Thank you. Could you confirm whether or not your client has a copy of the petition?
She does.
Very good. And do you know, have you asked her if there are any other cases that would concern the children that are concerned, her children that are concerned by this case? Child support, custody, visitation, guardianship?
No, she does have, she does, which is correct, attached to the petition, she does have sole parenting time with 2 of the minor children, with Mr. Doobie.
Custody, all.
She has custody, but you have exclusive parenting time, correct, for court order?
I don't understand what you mean by that.
You got a referee order from several months ago, from back in October, that suspended Austin's parenting.
Yeah.
Yep, that's right.
And Judge, I'm so sorry to interrupt, Mr. Noe, but I think that there is a little bit of confusion as to what was submitted versus maybe what the other attorneys received. Is there an MC 21 on the back of your petition, Mr. Noe? It should be the last page.
I didn't notice it, but it's possible. Didn't see it.
I do not have one.
I also don't have it. All I have is the petition itself and the attached referee's recommendation order.
Same here.
Yeah, so I received an email from the clerks with a full petition that we submitted. So my team, me, my secretary, Ms. Kelly Allen, and Ms. Jones received an email. And it has the full stamped petition of what was filed. And then there's a second email, and it seems that that second email had went to the rest of the attorneys in the public defender's office, and that is actually missing like 10 pages from the back. So I think that that's also an issue that we have to sort out. I did forward the stamped petition I have to the attorneys, but it does have more of that custody information attached to it.
All right, so you have the referee recommendation and order on parenting time, which is 2 pages. Is that right, Mr. Noe? That's what I have.
That's all I have.
Yeah, that's right. That's right.
All right, so in addition, what I have in front of me is a stipulated order on custody, parenting time and support, Faith Double versus Austin Doobie, and a judgment of support in Faith Double versus Jeffrey Patterson. And I could offer to you, obviously, Ms. Spencer will need an email copy, but I could ask my deputy to give you both copies of the other two documents I have today, if you would like, as well as that confidential case inventory.
That would be great.
My client will need to serve that also, Your Honor. I can look at his reflects exactly what I have.
All right, so how many copies do we need?
I think we'll be 1.
5? All right, Deputy Ames? 5 copies of these documents, please.
Very good, Your Honor.
Thank you. And Ms. Spencer, you'll have to rely on Ms. Thomas to get you your copies. All right.
Your Honor,
Oh, one moment.
Okay.
Have you checked with your client on the Native American heritage, Mr. Knapp?
I hadn't until just now, but she indicates to me the negative. She's not aware of any Native American heritage in her family.
All right. Does she know at all where Mr. Doobie is at today?
I haven't talked to him in forever.
She hasn't talked to him in quite some time.
Well, that's all right. That's it for now. All right, Mr. McFarland, same questions, comments on the sidebar?
Yes, Your Honor, my client has a relative who is living on a Native American reservation. His mother can provide the name and address of that individual in the tribe. So it's a little bit more information what's in the petition. My client is also agreeable to voluntary services. I do have right now a jury demand to submit to the court. If I might do so, be available.
Good. Deputy Ames, would you mind?
I hate to interrupt, Mr. McFarland, but I have that and also my limited appearance in this matter, so I can also present Deputy Ames.
Thank you.
Yeah, I know we have a jury trial date reserved. There is a distinct possibility that there will be a plea down the road at the next adjournment free. I do think we need to wait for the at least return of the Native American heritage documentation.
Ms. Spencer, my thoughts would be to just simply include that jury trial date for your client as well at this point. I know you haven't had a chance to talk to him about whether or not he wants a jury trial, but for the purposes of judicial economy and the time of our jury, I would be inclined to simply set yours as well for jury trial. And then obviously if you're able to talk to Mr. Doobie, you want something different, we can talk about it in the future, but do you have any objection to that?
I have no objection to that. Thank you.
Did you have any comments about the sidebar that you wanted to share?
I do not. I obviously haven't talked to my client and he's not here, so I don't have much to add.
Comments about our sidebar, Ms. Heiss?
No, nothing further to add, Your Honor.
Mr. McFarland, did your client, I know I have the support order that concerns your client. Are there any other cases that he's aware of?
Yes, Your Honor, there is. Jeffrey Patterson, there was a support case. He advises me, I imagine if there's support, then custody was also established.
Yes, I think that's part of what you're getting a copy of
Okay.
in just a few minutes. All right, each of you have the right to have the attorney represent you. If Mr. Noe is not able to represent you moving forward, for whatever reason, we would ask the Public Defender's Office to appoint you someone, ma'am. Each of you have a right to an attorney at each hearing, and that will be provided for you if you are not able to afford your own. Thank you for confirming that you've received copies of the petition. We'll look for the department to provide proof of service on Mr. Doobie or to do a written motion for alternative service documenting the efforts that have been made in order to locate him and serve him. And I'll be happy to look at that moving forward. We'll ask the department to ensure that they find the name of the tribe or as much information about the membership, tribal membership as possible and complete that inquiry. And I do find that that's a good reason to continue our prelim to the second date that's been cleared with all of the attorneys, as well as to allow the parties to continue to talk to their clients to decide what they want to do moving forward. But of course, we have that jury trial reserved and that's on the docket. So we'll be able to address any further issues or preliminary things at our continuation date for that particular prelim. I will ask the department to provide a proposed case services plan to each of the parents, including Ms. Spencer until we find Mr. Doobie, so that they can look at those proposed case services. If you want to engage on any services now, that would give you an idea of what to look at. So we'll look for that to happen between now and when we come back on the 29th at 1:30. Of course, not being asked to remove the children from the home at this time. There's only a request for in-home jurisdiction, and that is part of the petition itself, which all of you have a right to have read onto the record. I know there was a request by Mr. McFarland to give him some more time to allow his client to go through that, but I'm also happy to read that in our continuation. I know Mr. Noe has a hearing that he's got to get to at 10:30. So you can take that under consideration between now and when we come back if you like.
Your Honor, we will waive reading that today. This will give my client an opportunity to more fully digest that, and we do need it read. We have an adjourned date.
Yes. Very good. All right, you both have a right to a trial by judge or jury. As you know, you've been able to talk with your attorney about that, which is great, and you've proposed to that jury trial. At that trial, the representative for the department would have to prove that the statute's been violated by proving one or more of the allegations in the petition by a probable cause standard. You have the right, of course, to the assistance of your attorney for purposes of cross-examination of witnesses. You have the right to ask the court to subpoena any witnesses that you think could help give testimony in your favor, and of course, the right to testify yourself at that particular trial. The department will be obligated to continue investigating as well as to offer those voluntary services between now and when we come back and through the duration of our case. I would encourage you to take advantage of that if you're so inclined between now and when we come back for the remainder of our prelim on the 29th at 1:30 p.m. Are there any other preliminary issues to be addressed today, counselors?
Now that we've just received, as my client has the additional attachments.
We would acknowledge the same.
All right, well, thank you all for your time this morning, and we'll see you on the 29th at 1:30 p.m. We are scheduled to begin today's hearing at 1:30. Well, I've made some time for the attorneys to speak with their clients as well as to speak with each other. Okay, sorry, we've actually begun the board hearing, so let's try not to do too much interrupting. Ms. Spencer has just informed us she has a 3:10 hearing. I certainly hope that with the time that we have this afternoon, that all of you have been able to come to some good conclusions, and I look forward to the updates on how the case will be proceeding. May I have appearances, please?
Lee Heiss, lawyer guardian ad litem for the children.
Nastasia Thomas, counsel for the department. I believe Ms. Jones and Ms. Grant are present. Ms. Jones was our investigator, and Ms. Grant will be our ongoing worker.
Chelsea Grant, ongoing worker for the department. Amanda Jones, CPS investigator.
Good afternoon, Charles Noe, appearing on behalf of respondent mother. State your name, please.
Oh, sorry. Faith Double, mother.
Mr. McFarland?
Michael McFarland, appearing on behalf of one respondent father. Please state your name.
Jeffrey Patterson.
I'm sorry?
Jeffrey Patterson.
Thank you. And Ms. Spencer?
Alexis Spencer, appearing behalf of respondent father Austin Doobie.
Mr. Doobie?
Yes.
Could you give us your name for the record, please?
Austin Doobie.
Thank you. All right. Ms. Spencer, let's start with you. Have you reviewed the petition with your client? Do you have any reason to believe that he would need that read onto the record today, or do you know if he wants to waive that?
Yes, we can waive reading. I did go over it with my client. Thank you.
Very good. Are you aware of whether or not any other cases other than those previously disclosed apply to concern any child of your clients?
No, only the ones listed.
All right, very good. Do you know whether or not your client has any Native American heritage or reason to believe that he or his child would be eligible for tribal membership?
He did not inform me that that was the case.
You go over that with him once he's sworn. And how would you like to proceed?
He would like to enter a no contest plea and accept the case service plan.
What would be the basis for the no contest plea?
So there are some criminal, there is a criminal action right now that he was obviously in jail for at the time of the first hearing that he was not here for. So he obviously does not want to admit that he did anything in that case that could be used against him.
Yeah. Any objection to that? Ms. Thomas?
Yes. No, Your Honor.
Mr. McFarland?
No.
Mr. Noe?
None.
Ms. Heiss?
No objection.
All right. Very well. Let's go to you next, Mr. McFarland. All the same questions?
Yes, my client does waive reading of the petition, Your Honor. We wish to enter no contest plea based upon number 38, which are assault allegations against the minor child in this case, Your Honor. Specifically A, B, and C.
Have you inquired of your client as to whether or not there are any other reason, if there's no reason to believe that there's another case that applies?
No other
or whether-
cases.
Or whether or not he has any Native American heritage or reason to believe he would be eligible for membership?
And my client does, as we mentioned in court last time, they have some allegations of Native American heritage, Your Honor.
Very good. It does look like there were some inquiries sent, so we'll circle back to the department on that question. All right, Mr. Noe, does your client wish to have the petition read onto the record or waive that?
Let me waive, Your Honor.
All right, any other cases other than those previously disclosed that would concern her children?
None known, Your Honor.
Any reason to believe that she or her family members are members or could be eligible for membership in any Native American tribe or band?
Not that we know.
And how would you like to proceed?
Your Honor, my client would like to enter a plea of no contest based on one of the allegations, specifically numbers 11 and 12. In addition to that, my client would be in agreement to enter the case service plan with the modification of Al being just adding the words at the end of it as enforceable against her. That was discussed with counsel and also with Ms. Thomas. And I believe there's an agreement with that modification.
So she wishes to enter no contest plea and to proceed to disposition immediately? Because we typically would have a 28-day time frame in between, and
No,
It's up
that's
to you.
fine. That's fine.
Your Honor, my client would like to proceed to disposition. He has reviewed the case service plan. I believe he signed that. Did not? Okay, well, he's read it. He's willing to go into the case service plan.
As is mine with the one modification.
And my client is,
okay, all right, okay. Any objection to the no contest plea by the other two parents that you can pick up for any reason, Ms. Spencer, Ms. Thomas?
no objection.
No, Judge.
No objection.
Ms. Heiss, do you find it to be in the child's or all of the children's best interest in this case for me to accept these no contest pleas and allow the case to proceed through disposition as well today?
Yes, Your Honor, the children are placed with Mr. Patterson and Ms. Double, and this would allow them to get started on their services quicker and quicker towards reunification and closing the case. Thank you.
Very well. Deputy Ames, if you could please swear in Mr. Jeffrey Patterson, Austin Doobie, and Ms. Faith Double. Okay, Mr. Doobie, do you have any Native Americans in your family or have any reason to believe that you or
On my dad's side, he has to do, I'm not sure, I'm pretty sure it was, I'm not sure the name of the tribe, but they originated in Muskegon and, around like the Michigan area.
Great. Have you told Ms. Jones or Ms. Grant about those family members?
No, I have not.
Okay. Do you happen to have their names? Or do you know what their names were?
I know my father's name, Scott Allen Dooley, but,
Scott Allen Doobie?
yeah.
All right.
Scott Michael Doobie.
Scott Michael Dooley, sorry. What was his mom's name? Because it was like, she was like,
He passed away when he was very young, right before he was a year old.
I don't know anything about that. I don't
Have
know.
not been in contact with the family since.
Okay. What is your name, ma'am?
I'm Abigail Bregman, I'm his mother,
Abigail, how do you spell your last name?
Bridman.
All right, Ms. Brigman, would you be able to speak with either Ms. Grant or Ms. Jones about any other information you have about the Native American heritage potential?
I don't really have a lot of information on that. I just, through word of mouth, is all I have. I don't really have any.
I could ask my,
Okay, one at a time, please. That's the other problem that we've got is we're trying to make a record, and although I have certainly a video available online, when Ms. McGrath, if she has to do a transcript, it becomes very difficult when different people are talking at different times for us to follow that. So that's why I was asking if you wouldn't mind, Ms. Brigman, to just talk with Ms. Jones or Ms. Grant after today's hearing.
Okay.
Thank you, appreciate it. All right, very good. Okay, so all three parents, I am going to go over with you your trial rights. I have received your signed copies, which I appreciate. But I'm gonna go over them, I'm gonna go over your rights with you before I take a plea today. If you accept or enter a no contest plea, you are giving up the right to a trial by judge or trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe can give testimony in your favor. Do you understand that you're giving up or waiving the rights I've just indicated to you if you admit the allegations in the petition and enter a no contest plea, Ms. Double?
Yes.
Mr. Doobie?
Yes.
Mr. Patterson?
Yes.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court can terminate your parental rights. With regard to the plea itself, including a no contest plea, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. Double?
Yes.
Mr. Doobie?
Yes.
Mr. Patterson?
Yes.
You have any questions about any of the information I've given you so far, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Is anyone making you enter a no contest plea, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Has anyone threatened you in order to get you to enter a no contest plea, admitting to the allegations today, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Outside the terms of the plea agreement, which to my understanding is essentially simply that you're entering a no contest plea, has anyone promised you anything to get you to enter a no contest plea, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this afternoon, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Would you say your decision to enter a no contest plea is one you've made of your own free will, Ms. Double?
Yes.
Mr. Doobie?
Yes.
Mr. Patterson?
Yes.
Very good. As it relates to the no contest plea, you will not have to verbally acknowledge any violation of the statute. That would be up to the department to make a showing that there's been a violation of the statute, and then I would decide whether or not to find that and accept your plea. However, you are effectively identifying the issues in the petition with the entrance of no contest plea, and that is what the case services plan is built around, which I think I'm glad to hear that you've all had a chance to talk with your attorneys about that today, and that you at least indicated preliminarily that you understand what that's about, so that's good. All right, as it relates to the factual basis of the plea, Ms. Thomas.
Your Honor, typically I would ask for Ms. Jones to put that on record, but given the time constraints, I'm going to ask counsel if they would be agreeable to stipulating to the petition as filed to serve as a factual basis.
I would.
I would, but for number 30, it states that he is in jail and he's obviously no longer lodged there.
Sure, it's simply at the time that it was filed. At the time it was filed,
Yep.
Those were true.
No, Judge.
All right, very well. Ms. Heiss, do you find that to be acceptable?
Your Honor, I wonder if we could swear Ms. Jones and just have her attest that this is true and accurate. If she did sign it, you could accept that that is sufficient, but other than that, I do think that the facts laid out demonstrate what the family needs for services and how the case service plan will show a roadmap for reunification.
That sounds like a good idea. Ms. Jones, would you like to just step up to our podium for a moment? Ms. Thomas, would you like to lead that voir dire?
Sure, thank you. Ms. Jones, how are you involved in this matter?
I was a CPS investigator with the family.
Okay. And as the investigator, did you have the opportunity to speak with the family, have contact with the children, and review prior CPS contacts within the internal system?
Yes.
And did you sign your name to the petition that is in front of the court today?
Yes, I did.
And was that as a result of you drafting the petition that is in front of the court today?
Yes.
And under oath, do you affirm that the contents of the petition are true to the best of your knowledge?
Yes.
Thank you. I have no further questions, Judge.
Ms. Spencer?
I have no questions. Thank you.
Mr. McFarland?
Can I ask a question about the case service plan, Your Honor, or
You may.
for that? As far as priorities on the case service plan for my client, where should his priorities be?
That would not be me. That would be
You are correct, okay.
Question for Grant, Chelsea Grant.
I have no questions.
Mr. Noe?
None.
Very good. Thank you. Well,
No
Ms.
questions, thank you.
Thank you. Okay, thank you, Ms. Jones. All right. Understanding that the factual basis for the plea then is simply the court taking judicial notice of the allegations in the petition. Counselors, are you satisfied with the advice of rights and the factual basis of the plea?
I am.
Yes, thank you.
Yes, sir.
Yes, Judge.
Very well, thank you. The court is also satisfied there are indications of physical abuse, medical neglect, lack of supervision, and some other issues that have been well identified in the case services plan that's been engineered to help the parents understand both the effects that these things have had on the children, as well as how to develop some skills in order to create a better, safer environment for the children moving forward. I also find the plea to be knowingly, understandably, and voluntarily made by all three parents with a full understanding of the consequences that were reviewed on the record today. Moving into the disposition, each of you have the right to have 28 days to meet with the department, to look at that case services plan and to have input on that plan. And then it would become part of the court's order moving forward. And it is how I am able to determine whether or not you're making progress in those areas that are barriers. So if you would like to proceed into the disposition today, you'll have to waive that 28 days. Is that what you wish to do, Ms. Double?
Yeah.
Yeah, in terms of Ms. Double, again, the only revision we would ask, I don't know if the court has that, but it is agreeable, but with that one revision, we're agreeable to the case service plan.
Do you have a version of the case services plan that you like, that your client would want to?
I had one before I came to court, but I marked that up significantly. So I don't think that's gonna be acceptable to the court.
All right. Well, might be easiest then just to schedule our disposition. Which is perfectly fine. That will give you some time to look that over. And also you're welcome to begin your case services. If there are things that you want to get started on education-wise, some referrals for counseling or whatever that may be, you're welcome to get started on those before we come back.
That's fine, Judge, or I mean, I can also just submit to the department, it's an addition of 4 words to the end of one requirement of the case service plan. And that would resolve it today, but that being said, I understand the court's position as well, to be true.
Well, I appreciate that. Ms. Spencer, does your client have a case services plan that he wants to have entered today?
We were fine with the proposed case service plan. We did go over all of the everything included on that. So,
Mr. McFarland?
My client wishes to start the case service plan today, Your Honor.
All right. Is there another copy of a case services plan for Ms. Double floating around anywhere that Mr. Noe could potentially use to accomplish his goals for today? Actually, maybe I have.
I have a clean copy, I just have one though.
We have a court report that was prepared for today, as well as some proposed case services plans as part of that packet. I'd be happy to hand those over. Deputy Ames, if you wouldn't mind taking those over. We assume these are identical to the ones that have been previously circulated. Yes. There should be one for each parent, actually. Very good. So Deputy Ames, there should be one for Mr. Doobie and one for Mr. Patterson. If the two of you could look those over, please. And if that is the case services plan that you wish to have the court enter, I'll need you to sign that, and that will become part of today's court order. And find further for purposes of the adjudication that the factual basis for the plea has been met by the allegations in the petition, which I briefly visited on record, but there are certainly grounds to find that jurisdiction is appropriate.
Your Honor, I did just modify the one that was presented to me, to present that to the court.
I'm sorry.
I just kind of hand wrote a modification on mine. Is that agreeable to the court to enter that?
It's okay with me if it's okay with your co-counsel. Which I think Ms. Thomas was nodding.
Yes, Your Honor. I mean, as it relates to that specific element of the case service plan, the issue is ensuring that the department is only considering whether the parents are violating PPOs or no contact as issued by the court order or issued by court order as it is enforceable against the respective parents. So we have that understanding. I'm happy to put that on the record, but I believe that handwriting that in or simply stating it for the record will suffice for my purposes.
All right, Mr. Noe, what is it that you wrote in?
Modifications of section L It currently states State Double agrees to follow all PPOs and no contact orders set by Lenawee County courts. I added as enforceable against her and initialed that.
Any objection, Ms. Thomas?
None.
All right, objection or position, Ms. Spencer?
I have no objection.
Mr. McFarland, any objection to the amendment that was just read onto the record by Mr. Noe?
No.
No objection, thank you.
Very good. Deputy Ames, if you could collect that one for me. Mr. Doobie, I've received back a copy of the case services plan that appears to have been engineered for you. Is this your signature on page 3?
Yes.
You agree and you understand that you're bound to accomplishing these goals, and that will be what I'm going to be looking at this moving forward. Do you understand that? Mr. Patterson, I'm looking at a case services plan that appears to have been engineered for you. It's a 2-page document that appears to have your signature on the second page. Is that your signature? I'm sorry, what?
Yes, ma'am.
Thank you. And you understand and agree to be bound by these case services?
Yes.
Very good. Ms. Devil, final question for you. Is this your signature on this page 2 with the modification?
Yes,
All right. And you understand that this is what you're going to be bound to for case services moving forward?
yes.
Very good. Do you wish to take any additional testimony on the court report or anything else for purposes of the initial disposition, Ms. Thomas?
Your Honor, I think that given the time constraints today, and that the parents are agreeable with the case service plan, the court report, actually, I'm going to strike that. I do need to take testimony from Ms. Grant to admit that court report, as it does have some of our ICWA documentation.
Ms. Grant? Actually, why don't you just stay where you are for now?
Ms. Grant, we are looking at a court report that you prepared for today's hearing, and it also includes some ICWA documentation. As relates to the case or the court report, are there any updates or modifications that you need to make to it on the record?
On the record, so the information for ICWA as it relates to that is updated for the most of information that I had until today in the court hearing about Austin's potential, although we did send ICWA documentation for his children also, I believe, to Cherokee, which is what that the updates were. I believe it was the Eastern Band. The only other amendment or update that I have is in the court report. It was talked about how the children were referred to early on. I did get those assessments this late in this morning, afternoon before we got here. Did not have time to circulate it. I did bring enough copies for everybody, but I did get those referrals for early on.
And as it relates to the ICWA documentation, just something that I've noticed in my records that there's different spelling as relates to Mr. Jeffrey Patterson's name. How do you have it spelled in your system?
Jeffery.
Okay. Your Honor, may I inquire from Mr. Patterson if that is in fact the correct spelling of his name?
It is, Your Honor. I just asked.
Thank you. Okay. Well, with that, Your Honor, I have no further questions about the court report or the attachments. And move to admit them. Thank you.
Any objection, Ms. Spencer?
No objections. Thank you.
Thank you. They have received the court report, the ICWA documentation, and then it looks like there's one other attachment, which is an ISC report. And those will become part of our court file, as well, of course, as the advice of rights forms and the case services plans. Any other comments? The record today, Ms. Thomas?
No, Judge, just asking for 90-day review. Thank you.
Ms. Spencer?
No further comments. Thank you.
I did have the one question of the worker about priorities for my client, if I might ask that.
Sure.
Thank you. I see you also have a psychological evaluation in the case service plan. Where should my client's priorities be and who schedules the psychological evaluation?
Sorry, we schedule it. I have been in contact with Dr. Haugen's office. However, he is scheduling out until July. We do have a second provider that I located. I reached out to her, but I haven't heard back yet. It is a psychological. I'm not sure how late she is scheduling, and I know that both of them want to get started sooner rather than later. If hers is sooner, she does do virtual, which would be easier, I think, on both of these clients to work and the children in their care. And if that's the case, I'm going to make that ASAP.
As far as prioritizing in the case service plan, where would you expect my client to prioritize?
We're gonna start with the psychological, and the kids' trauma assessments. However, the oldest child's, getting him re-enrolled in therapy is also part of the parents' highest priority.
Thank you. Thanks for
Questions, comments, Mr. Nari?
Thank you. I would kind of echo Mr. McFarland. I heard his questions and your answers. Would you agree the same questions, the answers would be the same for my client as well?
Yes.
Okay. No further questions then.
Very good. Any comments as far as the record goes for adjudication, prelim, or disposition that we've accomplished this afternoon?
Just a piece of housekeeping, Your Honor. I did file a limited appearance in this matter, and that was only through today's hearing. So I would ask that my client, obviously she has the opportunity to rehire me or get a different attorney or whatever. But until that point, I would ask that until that point, I would ask the court to appoint from the defender's office to represent my client following today's hearing. Obviously, she ends up retaining me further on or somebody else, that could change. But for today, moving forward, please.
Right. Ms. Heiss.
I have no closing, thank you.
All right. Court finds all interested parties are given notice for purposes of today's preliminary hearing and waived notice as it relates to the adjudication as well as the initial disposition. And that was well documented on the record today. The court will issue the preliminary hearing order, the adjudication order, as well as the initial disposition order with all of the case services plans attached as reviewed and signed by the parents today. The children will remain placed with the parents. That is the safest and least restrictive under the circumstances, especially considering that they're voluntarily and eagerly, it would seem, ready to get into case services plans, which is great. We're going to have our first regular review for all three parents on July 23rd at 9 o'clock in the morning. Unless there's any questions, that's all for today.
Your Honor, I do have one
client
question.
wait in the hall. Oh, I'm sorry, go
Just
ahead.
briefly, Your Honor, as it relates to parenting time with Mr. Doobie, there was a prior court order that I believe Ms. Double was supposed to be exercising exclusive parenting time, from my understanding. And the recommendation is that parenting time remain suspended until there's engagement with services to ensure safety of the children. So if the court can just make a ruling on that part in its orders, would be grateful for the direction.
What is the position of the department on parenting time?
Right now, the court report from Ms. Grant indicates that we would seek for suspended parenting time for the time being until there's progress and benefit from services.
Is there a risk of harm associated with parenting time?
Your Honor, I admittedly do not have the prior court order up regarding how they ended up in this situation, but the contents of the petition also indicate inappropriate discipline and parenting skills.
Your response, Ms. Spencer?
Yes, I did discuss this with my client, and because the order from October 16th of 2023 signed by Judge Anzalone did suspend his parenting time until further order, we were fine with accepting that moving forward until he obviously gets his psychological assessment so that he can begin having supervised or therapeutic.
Very well. Ms. Spencer, if you come across something or your client is making progress and you'd like to revisit the issue of parenting time, I am also here before you come back for your next review. So feel free to reach out to the guardian ad litem, who's very familiar also with bringing things to my attention in between hearings in the event that something changes.
Okay, perfect. Thank you.
Ms. Heiss, would you agree with the position offered by your co-counsel?
Yes, I do, and I believe the agency's plan is to continue the visits with Mr. Doobie's parents, who are very bonded with the children, so that he will have some assurance that the kids are doing well through his family connections while he gets treatment or whatever we can do in the meantime.
That's great. Glad to hear that. Thank you. All right, I will include that then in the order. The suspension of parenting time would continue then until we come back for our next review or until I've had something and you receive an order otherwise. I will not have the court orders for you immediately today, but they should be coming to you within the next few days. Any other questions?
That jury trial will be off then for the 22nd and 23rd.
Yes, but I will expect to see you back for the review on the 23rd.
My client says you can just mail him his order.